Okay, I think we are live. Hi everyone, welcome. Today we have a very interesting topic. Actually, I get questions all the time from parents about this. Parents always, a lot of parents have to deal with court, and then they go to court, and then they always ask, how do I fight this? And is there any case law, and how do I apply this? And have you seen this before in court, and that kind of thing. So anyway, the reason we have this today is really exactly to discuss that. Now, the topic is specifically about case law in Canada, but the insight is going to be really helpful for you. Doesn't matter where you are. So I hope that you stay tuned in. We have the honor to have with us an amazing attorney in Canada here, Attorney Brian Ludmer. Brian, welcome, and thank you so much for being here with us.
Thank you. It's a pleasure to be here.
Thank you. So, when it comes to case law, I get a lot of parents that would write to me and go, have you seen case law that is, have 3 children, and then they, they do X, Y, and Z, and then they do this and that, and then now I get to this point, and do you see case law like that? Can I apply it? And I can see that a lot of parents don't understand what case law is. So could you please explain what it is and why should we care and how does it apply? I know this is a huge question, so take your time with it.
Okay. All right. So the first thing is there's obviously a statutory framework within which we try and help families restructure in a healthy way after separation. And in any one particular case, the statute provides just that sort of background framework against which a court will issue orders that are binding on a particular family that will guide them to a particular parenting plan they have to follow that they weren't able to work out themselves. Okay. Sometimes that court order results from a consent. So the family might have been heading to court, but then they enter into a consent and a court order is issued. And that's the parenting plan that they follow thereafter. If they don't agree on a parenting plan and a court has to adjudicate the matter, then there'll be some sort of decision, most of which get published and reported, where a court will go through its analysis, its calculus of the evidence before it, and come up with a parenting plan and explain why that was the parenting plan that was felt to be in the best interests of the child or children. So that body of case law builds over time. How does it work? How do judges think? What do judges look at? What are parties supposed to bring forward in their own evidence to assist the court in making an optimal parenting plan? And so the study of that case law informs how the background statutory structure is going to be applied in practice. We call the body of decisions that have built up over time the jurisprudence. Now, over time, even in a country like Canada, you wind up with hundreds of thousands of family law decisions, almost so much that it's inaccessible. It's kind of like when I speak about parenting, and I explain to people that if you put in the term, parenting books on Amazon or Indigo, you get 125,000 hits. There's so much there that as easily accessible as the search engine is, it's inaccessible because no one is going to take the time to go through all the resulting search results. So thankfully, there is a process where others go through all the decisions as they come out, and people write articles, people write papers, and the community kind of rates or ranks the decisions for how useful they are as a precedent for another family. The ones that provide really good, broad, deep analysis get frequently cited in other cases, and therefore in that sense become even more persuasive. It's somewhat similar to the way Google does its search results, by looking at links, and if communities of people around the world are frequently going to a particular website for a particular topic, that'll bump it up in the Google rankings because the worldwide community has said it's meaningful. And so we have somewhat of a process like that, but we have a further process because we have a court structure that is a hierarchy. So courts are informed not just by other decisions by courts at the same level, but they're obligated to follow, not just find persuasive, but follow the guidance of superior courts. So if the Ontario Court of Appeal has a decision out on a topic, that's binding on the lower courts. It might be distinguished because the facts don't quite match up, or it's a different sort of situation, but for whatever that case stands for, it's binding on the lower courts. So that helps us navigate this huge body of decisions as well. Decisions of other provinces can be persuasive, but by definition are not binding as between the provinces, and decisions of the Supreme Court of Canada are binding everywhere. The one reason why Canada's jurisprudence has advanced very quickly in certain areas, and parental alienation being one of them, is that our courts don't hesitate to rely on decisions of other provincial courts that are really good, really insightful. And the one decision that I always use is a 2007 decision of the British Columbia Court of Appeal.
Yeah,
Sorry?
I think before we go into the
Sure.
specific, cases,
Mhm.
could we, I mean, that was a lot. Do you mind if I can just break it
Please, go
down?
ahead.
Yeah.
Go
Yeah,
ahead.
and thank you everyone in the chat room. Hi Joey, hi Maria, and Lisa, Kimberly, and Mary. Amy, thank you guys. Can you guys hear properly? Let me know. And yeah, thank you for the question. We're gonna try to pick them up, so feel free to post your questions. Okay, so from what I could get so far, I just want to make sure parents don't get lost. So from what you're saying, okay, so parents, in the past, there's different court cases to do with family law decision, and then some of it are by consent, some of it, the court adjudicated that. So if the court adjudicated that and make a court decision, some of it get published. When does a decision get published and when it doesn't?
I actually wish I knew, because sometimes it appears as if there isn't much science to it, but there's a publicly available free data set of most Canadian decisions called CANLII, CANLII.org. And it's part of a series of similar sites in several countries. Like there's Bailey.org, which is for England and Ireland. And I forget what the US one is called. But there are also for-pay commercial services that do a more thorough job of making sure to pick everything up. And one of them is LexisNexis. Another one is Westlaw, which is the Canadian side of that is Carswell. And sometimes those tend to be just a little bit more thorough in their coverage and making sure to grab everything. But, for the most part, if you're researching something and you do it on Canley or Bailey for British jurisprudence, it's pretty thorough.
Okay, thank you. So any of these decisions that are published could potentially be used. You could potentially cite them. Is that the case, or only a few?
That's correct.
Okay.
So in Canada, we don't have a counterpart to something that I've seen in the United States, in certain states, in particular California, where a decision comes out and it's referred to as an unpublished decision or a published decision, even though it's physically published. An unpublished decision, for whatever reason, whatever their standards or criteria are, cannot be used as jurisprudence in another case. So it's there, it's binding on that particular family. It's available for everybody to see how the court was thinking through the issues, but it can't be used as a precedent in another case. And to this day, I don't really understand why. But obviously a U.S. lawyer would know why.
Okay, great. Thank you so much. So this family law decision, once they consider published, they can be cited and they form into this body, that you could potentially reference. But there are cases that are being used more frequently, and those cases tend to be more persuasive. And if they come from a higher court, then they are binding at the lower court.
Correct.
Okay, thank you so much. That's really helpful. Okay, I hope that's clear for everyone as well. If you guys have more questions before we go into the specific cases, please let us know. I saw Anne just asked about where to find these. I think Brian just listed a bunch of websites. We're gonna put in our comment the specific link, but he mentioned Canley, Bailey, LexisNexis, Westlaw. So we're gonna put a bunch of links in the comment later after the event for you guys. So now that and then also you mentioned about, like, if you are in a different jurisdiction, so in Canada it's about provinces, and in the US, if you reference a case in a different state, it may be persuasive, but it's not binding. So that's also helpful to know.
Yeah, exactly right. Now, Canada tends to be more open to referring and reading cases from other provinces. In my experience in dealing with U.S. lawyers, the states less so, almost to the point that it would be completely unhelpful to refer to a really good, insightful case in New York in a case that's being fought in California on a similar topic. And once again, pardon the pun, but that's foreign to me because we tend to be fairly open. No one province has an exclusive on smart judges. So recently, in the bi-monthly publication of the Parental Alienation Study Group, I wrote an article that is just an ode to a recently deceased judge in Montreal, Justice John Gomery, who wrote a stellar decision back in 1991, 30 years ago, that was so far ahead of its time in terms of succinctly stating the dynamics in an alienation case, and really led to an acceleration of the Canadian law, that it still resonates today. And I've used that case in almost all of my cases because of the eloquence and the insightful comments from the late Justice Gomery. So you'll find wonderful pieces of judicial rhetoric that should become timeless. And we shouldn't just trash our older jurisprudence, because human nature is human nature and the needs of children and adults remain constant. Just because it's older and you want to use fresher stuff, that's a timeless decision. I give you one or so from that case. One famous piece of rhetoric for those of your listeners who have unfortunately experienced a child who is really alienated from them. Justice Gomery wrote as follows: hatred is not an emotion that comes naturally to children. It has to be taught. Okay, now that's just a beautiful piece of rhetoric. Another great one for use in non-contact or resist refusal cases is from a 1996 case, I believe, out of St. Catharines, where Justice Quinn famously stated, "The job of a parent is to parent." In other words, you're not the child's friend, you're the child's guide. And if your child is not going and seeing the other parent and there's a court order and the Children's Aid Society is not saying don't send them, your job is to get them there. And you can't just say, I encourage them, and hide behind the word encourage. And all of that and so much more is bundled just in that piece of rhetoric. The job of a parent is to parent. And so I continually use that, and I hope that we don't use that piece of rhetoric. I'll give you two more examples to stress the point, both the importance of jurisprudence per se, because to state, oh, I only want to use very recent cases, I don't want to use anything old, is really to do a disservice to some really great thinkers and all the effort put into previous cases where the same struggle was taking place. So one thing I want to point out, having done a lot of work in the parental alienation area, is what does it really mean? It's a colloquial expression. It is not to be found within any specific clinical work, but yet we all see it. We have a sense of what the user of the phrase is trying to say. So it's two words that have a ton of meaning to it. Well, the best description of parental alienation I've ever seen is from a psychologist in a Manitoba case from 2012. But it is two lengthy and one short paragraphs long. Basically takes up a full slide if you're doing a PowerPoint presentation. So it's bang on, but it's too long to use it in a discussion about what's going on in a family. It could be that thing, that process that psychologist in that case was referring to. Well, then you got something a little bit shorter, or it could be parental alienation, and we just refer over. So I've been trying for years to have Ontario judges recognize the beauty and the eloquence of Dr. Stambrook of Manitoba, his description in that 2012 case, which I believe goes by the acronym LMAN, part of a series of decisions in that case.
Is it okay if we go into these cases like more specific in a little bit, like wait, if you could?
Sure. I'll just finish the thought and then we'll move on.
Yeah.
So took me a while, but I finally got an Ontario judge to adopt it wholesale and state that she agrees that that's exactly what it is. Okay, so here's where older cases and other provinces can inform newer cases in other provinces. And so as a body, the jurisprudence keeps improving. And that's the pitch I want to make.
That is awesome. That is really great. Because what you just did is you renew something that was fundamentally, important, but people were kind of not comfortable using because it's older, right? So now you have it in another decision, and now this new decision is brand new now, and you get to use that foundation.
Correct. I've freshened it up.
Yeah, that's fantastic. Thank you. Thank you for your work. You're really helping a lot of parents out there. So I saw in the chat room, Kimberly mentioned that parental alienation is not being recognized in the DSM. I want to let you know that it is being recognized in DSM in at least three places. If you check on our Facebook, we have a couple of posts mentioned about this, and we let you know exactly where it's being listed. And also in our Facebook group, which is Parental Alienation Victim Support Group, we also talk about this. So it is in the DSM. The other thing I saw was that Kimberly asked, where's a link to the article? So Brian mentioned about an article that he wrote recently in the PASG newsletter. Now, PASG is a parental alienation study group. It's free to join. I highly recommend all the parents to join. It's free to join. The website is pasg.info. So you go there, and it's very simple to join to become a member. And then once you're a member, you get a newsletter. And if you miss the newsletter in the past, is actually on the website. There's an archive where you can go in and you can look at all the past articles. The past newsletters. And then so Brian's article was in the PASG newsletter. And there are many other articles out there. Every edition, there's an article about the legal aspect of it. There's article about all sort of things. So there's all these different topics that are being covered in the newsletter. And the PASG is a body of really amazing experts in this field. So I highly recommend all the parents joining that. So just wanted to add to that. Okay, so you mentioned, Brian, so let's get back to the topic. You mentioned that so parents sometimes, or people are sometimes not comfortable referencing older cases. So what do you do when, let's say you try to cite an older case and then the opposing party trying to use that argument that this is the older case. Like, what if they try to use that as an argument? And sorry, before you answer the comment in the question, and you said PSG. Yeah, you type it correctly. It's an abbreviation for Parental Alienation Study Group. So pasg.info. Okay, Cynthia just posted the link there. So thank you, Cynthia. But yeah, Brian, yeah, please.
Okay. Yeah, I guess it's human nature to always think that newer is better. But if it's a well-known judge, and if it's a decision, because you can tell in whatever service you're using how many times it's been cited by other cases, then it will have persuasive merit. Okay, and then you have to have counsel, argue it, take the court to it, and explain why it's persuasive and what it tells us. But there is a tendency to continually freshen up and refer to the more recent iterations of jurisprudence, and I think that's perhaps to the detriment of the development of the law. That there are certain absolute gems of cases that we need to continually go back to, because the judge just absolutely nailed the issue and explained it in a very persuasive and sometimes entertaining fashion, or just those pieces of judicial rhetoric that I mentioned that are just so perfect, and they say so much in one or two sentences that they're worth repeating.
That's great, thank you. So what about, I'm sure you have seen this, it's not uncommon for when the courts sometimes have conflicting decision. It seems on the surface like it's the same situation, and then yet in one case, the judge would have this decision, in another case, the judge would have another decision. So the opposing party might try to pull the conflicting decision. How do you deal with that? I guess the question is really coming down, how do you apply a case law to your situation? How far does it apply?
You're going to try and extract principles from previous decisions, because you're never going to find something where the facts are identical to another family's journey. Sometimes you find cases that are remarkably similar, but you're really looking for the principles and then applying the principles that the prior case law teach us to the particular facts of the family. And yes, with the number of family law cases out there, you're frequently going to find cases that go both ways on a given situation. And at that point, your task is to, once again, go to the principles, because you could even cite a case where the ultimate decision on the facts of that case was, say, not to intervene, but the principles that that case applied actually help you on your own facts. And she'll do that. In that case, because of fact A and B, the court saw it the other way. But the principles stated in that case really resonate here. And because of our facts, C and D, I'm submitting the court should find it the other way, kind of thing. Okay?
Yeah, so it's about looking at the analysis of the court decision, right?
Correct. Yeah.
And that's why you were saying how there's some cases the court will go very deep into its analysis, and that become a lot more helpful, right? A lot more important cases.
Correct.
Okay. So so let's go into the specific cases, and if you wanted to, like find a case and share screen, feel free to do that. Let's talk about cases that you find particularly helpful to prove parental alienation.
Okay. So what I really want to take people to is first that British Columbia case that I was referring to. So it's a 2007 case of the British Columbia Court of Appeal, and it also goes by the family's initialized. So it's AA versus SNA. And once again, it's part of, you often see this, there's like 8 or 9 cases in the chain spread over several years for that same family. But this is the 2007 attendance at the Court of Appeal. And what is so remarkable, what resonates even today, 24 years later, is how the court dealt with the number one struggle that we still struggle with today. And that is, you have a fractured family system. We've thrown everything at it we can. There's rampant noncompliance with court orders. We've tried 3 different types of therapy. They've all failed. What's left? At that point, and judges have admonished the parent who's not following the court orders. They don't seem to care. What's left? You're really only left with 2 options. One is the parent seeking parenting time has to just give up and the child loses a parent. Or the other thing that's left is a temporary protective separation where the favored parent has a timeout and the other parent gets some makeup time and the family gets some highly specialized therapeutic interventions. And then after the children have learned to reattach, if you will, because that's attachment theory, to their formerly rejected parent, and that relationship is considered resilient, and the favored parent, it now comes to understand how they were undermining, we move them back in. The whole goal of that sort of intervention is it's temporary. It's a short detour along the way toward giving the children back to parents. We're not just replacing one parent with the other parent so that the kids still experience a loss. This is just a little detour, and kids understand the concept of make-up parenting time to get back to a healthy family. Now, the struggle that I referred to, the hardest thing in this area of law, the court has to struggle with, are the kids going to be traumatized by being placed with the rejected parent? Is the cure worse than the disease? And of course, the argument that comes from the favored parent and often from the children's lawyer, if there's a children's lawyer in the case, is that's exactly what's going to happen. The children will be traumatized, the children will run away, et cetera, et cetera, et cetera. Well, experience has shown, and prior decisions have shown, that if it's done properly, they're not traumatized, they don't run away, and things can actually heal pretty easy. So in other words, the disease, the inevitable loss of the estranged parent, who a court has found to be just, an average worthy parent. No reason why the child has to lose them.
I'm sorry, is this the case that we are talking about? Let me just zoom in a little bit more. Is this the case?
Okay, it could be, but you have to just scroll down so that I can just see it.
A mother, 10 years old child refused to allow father to exercise.
Yeah, no, I understand, but keep scrolling down.
Okay.
Okay, scroll up a bit.
Okay. All right, okay. So I don't have access to it.
Okay, hold on. Yeah, just leave it there. Yeah, this is the one. Okay. So in this case, the trial judge, while the trial judge found alienation, the trial judge was, as you can see here, while the relationship with the mother was detrimental to the child, a forcible removal might cause the child great damage psychologically. The father appealed. British Columbia Court of Appeal allowed the appeal. The trial judge erred in focusing on the short-term difficulties of change. He failed to give paramountcy to the child's long-term interests. The obligation of the court to make the order that best represented the child's interests could not be ousted by parents' intransigence. Okay? So this was a breakthrough decision because it tackled squarely what courts in all of these cases where you're having to choose between two difficult outcomes, and this is what they struggle with. And what this case, you have to read the whole case to really get the flavor, but what this case said is it's an error in law. So there's no deference to the trial judge to place too much emphasis on the anticipated short-term risk of upset to the child at the expense of the evidence-based concerns about the long-term impact on a child of losing a parent. It is only this temporary reversal of custody that gives the child the chance to have two parents in the child's life. Okay? Now, it would not be until 2020, just February of last year, that the Court of Appeals for England and Wales made a somewhat identical decision, reversed a trial judge who found clear alienation, but who was concerned about the risk of upset to the children, and was then overturned by the Court of Appeal for England and Wales. So here you have two different countries, human beings, family law litigation, issues and principles are the same. And I would bet anything that this British Columbia decision was not put before the Court of Appeal for England and Wales. But recently, I won my third Ontario Court of Appeal decision in a row where I was defending a reversal of custody at trial level. And I cited both this 2007 BC decision and the 2020 decision of the Court of Appeals for England and Wales, just to make the point that that's what we need to do. By definition, if we've tried all the other interventions in the meantime and nothing has worked, then you do this little detour before you just give up and accept the fact that the child has to lose one of their parents. And quite often the healthier parent, of course, is the one that the child's rejecting. So extremely important principles that are still timely that we struggle with today. And you've got to go back. It was very hard to get reversal of custody back in 2007. Not that judges didn't do it, but it was a rare occurrence. That case.
Sorry. Hold on 1 second. I'm sorry. In the chat room, someone said that the video is paused. Could you guys please let us know, because I don't want you to miss this. Is the video still working? Could you let us know before we go on? I apologize, Brian. Could someone let us know if you can see us, you can hear us? Is it still going? I'm not seeing any response. Okay, Cynthia, thank you. Thank you so much. Okay, I apologize, Brian. Please.
That's okay.
Yeah.
So here again, we have the importance of not forgetting the breakthrough cases of the past, because they just speak to a human reality that 20 years from now, that BC Court of Appeal case will be equally as relevant. And you can see how it has the potential to resonate in other jurisdictions. It's just speaking about the human condition. So I put that, high up on my list of go-to resources.
Thank you. And that's such a great case, because we hear this from a lot of experts. When you deal with an extreme, severe case of alienation, that the child is being put through so much that the alienators completely, blatantly ignore the custody order. Really, when it gets to that kind of situation, the solution has to be to take the child away from the alienator temporarily until things are fixed. We hear this from experts. So it's so great that you point out this case, that you can actually have a tool legally to point out that, yeah, this is working, this is the right decision. So I think this case is so important. I don't know if you guys saw, you mentioned that the screen was paused for a while. So I don't know if you saw that I share on the screen the case, and if you didn't see it, it's British Columbia 2007 case, AA versus SNA. Yeah, if you can search for it, you'll find it. And then, like Brian mentioned, you can read make sure you read the case, but essentially the case is for a very extreme, severe case of alienation. And the court at first was worried about taking the child away from the mother, who is an alienator, but then later they reversed that decision and decided that the long-term best interest of the child is more important than the short-term. So they decided to give the father custody. Please go ahead, Brian. And so that was a great case. And then you mentioned you also usually reference another case. What was the other case that you referenced?
Okay, so the most common defense of it, and it doesn't have to be an alienation case, just a case where a parent is not producing the children. Their most common excuse is well, I'm encouraging them to go, but I can't get them to go. But at the same time, they're saying all kinds of negative things about the other parent, kind of justifying the children's decision. So, you know, it's the kid's decision, and I can't get them past that, but I'm encouraging them to go, but I understand why they don't want to go. So sorry, I can't help, and I shouldn't be responsible for the kids going. Very, very common situation, something we face all the time. And as one would hope, there's tons of case law available to refute that assertion. So first is that safe harbor that all these parents hide behind. I'm encouraging them to go. Is that sufficient? Can't be an argument of first instance, got to have been argued in the past by others, and indeed you see that in every case. You know, I think the mother is totally abusive as a parent, and I've seen her hit the kids and ignore the kids, et cetera, but I'm encouraging them to go. And you literally see that. You know, I'm sorry, it's one or the other. If you really believe that, you're not encouraging them to go. So how do we get past that? Well, earlier I referred to Justice Quinn's decision in 1996 out of St. Catharines. The case is called Jeremiah, Geremia versus Harb. It's also part of a whole series of litigation. These cases, they're in court, they're out of court, they're back to court. And in this particular one, you find that piece of rhetoric that the job of a parent is to parent, which is great, and I cite that all the time. But is there something even more helpful in delineating exactly what it is that we are expecting the favored parent to do? If we want to call them to account and make them responsible for not doing something in support of the court order, what is it that they are supposed to do? So when I first started working in this area of law, and I did all this research on parenting and etc., I boiled down, this is kind of my own rhetoric, the job of a parent as fitting within 4 categories. Guidance, we provide guidance to the children because they don't know, they don't have the experience, they can't see the danger, they don't have the perspective, they haven't lived long enough. They're about to make the same mistake that we made as kids, that we kind of prefer that they learn it without learning it the hard way. That's guidance. Then there's boundaries. So there are certain things that speak for themselves that I'm going to express to a child as it's not up for discussion, not up for debate. I cannot compromise on this issue. It's a safety issue. Yes, you go to school even though you don't want to go to school. Yes, you follow court orders even though you don't want to follow court orders. Yes, you avoid illicit drugs even though it sounds exciting and your friend's doing it. Why can't I do it? Okay, so these are what we call boundary issues. You don't stay out all night with your friends. You come home and sleep so your parents know you're safe, etc. A boundary issue generally should be one that speaks for itself. It speaks for itself, the safety element and the importance in terms of child development speaks for itself. Because generally we want to be in the guidance category where it's kind of what we call authoritative parenting instead of authoritarian parenting. Authoritarian parenting is, I'm the parent, I'm at the top of the pyramid in the healthy family hierarchy. I've thought it through, so I've said this is what's happening, and therefore this is what's happening. Is not the healthiest style of parenting. You want to engage. You want to bring the child inside the tent. You want the child to understand your own calculus as a parent, even though at the end of the day, the decision may not be what the child wants, but you've allowed the child to participate in your calculus as a parent so that they can understand. It's a lot easier to accept a decision that you understand, even though you're not happy about it. You feel heard. The calculus is transparent. And when you grow up and you're a parent, you can play it a different way. But for now, your parent loves you, and this was their parenting decision after engaging with you, after hearing you out, after exploring potential compromises. Because a parent in a custody battle is in a loyalty bind and may have to move the dial down a little bit, be a little bit more permissive, even though they might be the parent who has more structured parenting style. And that's perfectly normal, perfectly fun, perfectly normative. We'll raise a healthy child. But given the situation, it's too hard for the child to go from the permissive house back to the structured house, back to the permissive house. It's hard. And what do you think the child's going to choose? The permissive house, even though it may be too permissive. So you got to kind of show the child you're prepared to compromise, and you're asking them to compromise and meet you in the middle. That's part of authoritative parenting as well. So we have guidance or authoritative parenting, boundaries, incentives. So if I want to get good behavior from a child, like, yes, I really do want you to go see your mother on this schedule so I don't have to go through this with you every single time. And I know you're using the iPhone 7 and you're dying for the new iPhone 12. If I see you doing that, I may be persuaded to get you the iPhone 12, to recognize that you're doing your part in the family for family peace and harmony. Okay? That's an incentive, something that the child might not otherwise have gotten, but in recognition that the child is making changes, doing their part, sure. Okay? And the last category of the 4 pillars of parenting, as I synthesize them in doing an enormous amount of reading, is consequences. And I came up with that term deliberately avoiding the word punishment and deliberately avoiding the word discipline, because there is a difference. Phrasing the denial of a privilege or a change of mind, no, I'm not going to get you that iPhone 12 after all, as a consequence instead of a punishment, means it's a learning moment. So childhood is the safe time to learn that you act a certain way and there are consequences. And I usually use the example of school. When you're in high school, if you don't show up or you don't hand in an assignment, there's some accountability back to the parents. They'll send a note home, etc. The minute you hit first year university, you are literally a number. My student number at U of T was 258 something, whatever. That's all you are. They make sure to take your money at the beginning of the year. And if you don't want to hand in your assignments, you don't want to write the exams, you don't want to show up to class, no problem. We always have a waiting list of students who are trying to get in. And you want to fail out, like, no problem at all, and we'll keep your money, thank you very much. That's a very damaging way and far too late in your development to learn that there's a consequence to behavior. So we want kids to learn to be accountable because the choices they make in life have consequences. So it's more of a learning thing. then, you know, I'm going to make you feel bad. For that reason, that's why I chose that word. And quite often I find myself in these semantic battles where the other side says, oh, Mr. Ludmer, your client just wants to punish the kids. No. And then I give the same explanation that I just gave. So guidance, boundaries, incentives, and consequences. So we go back to Justice Quinn and Jeremiah and Harb. The job of a parent is to parent. Sounds great. What does it really mean in the context of someone's not seeing their kids? Well, it means you're going to use guidance, boundaries, incentives, and consequences in your parenting of the child, and you're not going to stop until they're doing what they have to do, exhibit healthy behavior. If they were refusing to go to the doctor or refusing to go to school, you wouldn't stop like, well, I offered to buy them an iPhone 12 and they still won't do it, so I guess we're stymied. No parent's going to give up if it's really meaningful to them. You're going to try something else, and you're going to keep trying other stuff and keep deploying stuff in all those four categories until the job is done. And in our context, it means until the child is back regularly following the court-ordered parenting schedule, because that avoids antisocial behavior. Okay, so I then kept looking. Can I find case law, jurisprudence, that adopts, it wouldn't be one of my cases, so they wouldn't have gotten it from me, but that uses similar language? What does it mean to say that the job of a parent is to parent? It means use your full parental authority to have your child exhibit compliant and respectful and loving behavior. Well, in 2015, the Ontario Court of Appeal, in a case called Goddard versus Goddard, did exactly that.
So how do you spell that?
I don't know whether there's two D's or not, but I think it's Godard, Goddard versus Goddard. It could be that there's two D's in the middle, but it's 2015 Ontario Court of Appeal. Okay. And what the Court of Appeal said in that case was a parent is expected to use their normal parental authority to get kids to follow court orders. And that the word encourage, I encourage them to go. I understand why they don't go, and I can't make them go, and they have good reasons not going, but I encourage them to go, and therefore I'm immune. You can't touch me. They said, not good enough. You must demonstrate. You can't just say that you used your full parental authority. You need to demonstrate exactly what have you done. That's the takeaway from Goddard in 2015. The very next year, in 2016, one of Canada's leading legal jurists, Justice Chappelle in Hamilton, her decisions read like textbooks. You could learn entire areas of law just by reading those decisions. So much effort is put into them. So Justice Chappelle, in a case called Jackson in 2016, took that thought from the Court of Appeal and came right up to adopting my rhetoric: guidance, boundaries, incentives, and consequences. She effectively said that, but the examples she gave were of incentives and consequences. And I'm using those words. So you have a basis now between those two decisions. There are many, many others in the law of contempt of court that speak to what it means to be a co-parent. It's a very rich area of law. probably because, unfortunately, the dynamic happens so frequently. And I have a very, very thorough statement of law that I use in those cases. So once again, the power of jurisprudence to further the knowledge base. I then have several of my own decisions that build on that. Michener and Carter out of Barrie in 2018. Another case out of Milton in 2019, and most recently a case out of London in 2021, that all flesh out this area of what it means to be a parent, what is expected, and you got to walk the walk. You can't just talk the talk. So the power of jurisprudence, the power of learning, the clarity. Lawyers are therefore able to sit down with their own clients and say, let me show you why we're going to lose if the other side takes us to court. See this here, see this there, see this there. So unless you're walking the walk at home, it's going to be real tough for me as your lawyer to make the pitch that you're encouraging, but you're absolutely stymied and the kids have voted with their feet and nobody can do anything. It's going to be a very difficult day in court. So these decisions also give lawyers for favored parents the tools to get their own client to change their behavior. So these are just some examples of really good and ever developing areas of law that once you really get it, you really know it, you got those core decisions, and you just keep watching for other decisions, citing those decisions. And if they're really good, they become part of the collection of cases as well. And then you can make a very good pitch in court. Okay. Now, I want to mention the 5 or 6 aspects of the law applicable to alienation cases that have been answered by the 3 Court of Appeal decisions that I won. The first one was Wiggins in 2015. And that case, where I successfully defended a trial judge's reversal of custody, answered a couple of questions. First, is this reversal of custody a final decision or an interim decision? It's a lot easier in hindsight to look at it as it's just a detour. It's an interim decision. Courts should not shy away from it. If you've tried everything else, and in all likelihood, one parent is going to have to walk from their children's lives and the children will experience that further loss. Try this first. Because if it works, great. If it doesn't work, it's only an interim remedy anyway. And the judge stays seized of it, then you have a review 6 months out, you see what happened, and you regroup at that time. Hopefully everything's worked out and you're starting to reintegrate the favored parent. So that was one question that Wiggins answered. Actually made it easier to get these reversals of custody.
What's the case?
It's called Fiorito, Fiorito versus Wiggins, Wiggins, 2015 Ontario Court of Appeal.
Thank you. Yeah.
Okay. The second question that case answered was, in litigation, like litigation is not supposed to be trial by ambush, right? It's supposed to be a fair fight, so to speak, or that everybody's fully prepared for the issues that the court will deal with, and that will make sure that the court has the best possible evidence to figure it out. Okay, so in Wiggins, the father was the kind of estranged parent, and as we got to the second of two trials, there was a trial in 2011, judge found alienation, gave mom one last chance to change things around, then he was going to have a review. The review took place in 2013, and the review found that it had even gotten worse. Mom hadn't changed. We need a protective separation. But the father, he just wanted peace. His position was should be equal shared parenting. He wasn't after revenge. He wasn't after you did it to me, I'm going to do it to you. He had a clear vision of equal shared parenting. And he also wanted to, protect himself on costs, because if you ask for the moon and, you don't get the moon, you could win, but still be denied costs because you didn't get what you were asking for. So he wanted to be reasonable, practical, but also send a message that even after everything that had been done to him, he was just after peace. But it became apparent through the trial that there never would be peace. That the other parent saw nothing wrong in what she did not subscribe to guidance, boundaries, incentives, and consequences, hid behind encourage, then there would be no peace. So in other words, if a court imposed 50-50, you'd have a breach of that court order. There was already a breach of a court order where he had less access. So you get to the end of the finish line after the whole trial, and you say, I know that's what I was asking for, but it's not going to work. I'll be back again. So in closing submissions, for the first time, we raised this issue. And of course, a bit of a surprise to the trial judge. Other side, of course, saying it's too late to expand the relief that you seek. But what Wiggins stands for, because obviously the trial judge accepted my argument that remedies are always in the discretion of the court. As long as the issues were known, and of course all the issues were known, can't go on like this, what is the cause of the family dysfunction, etc. The particular remedy is always in the discretion of the court. The court can ignore what both parents want and impose its own parenting plan, because that's what it's all about. What parenting plan does the court, and if neither parent has thought up or is willing to propose the parenting plan that the court feels is in the best interest of the children, the court has full discretion. It's not like commercial litigation where you're limited to the relief that you're seeking. You can't suddenly at the last minute say, oh, I want $10 million more. I've decided based on, okay? It's different here. So obviously the trial judge accepted that, and the Ontario Court of Appeal upheld that. So you don't have to go into a trial with the heavy hitter of, I want this protective separation thing because nothing else is going to work. It means you could theoretically go into a trial with alternative relief. So my preference, like in my orders requested at trial, my preference is for equal parenting. But if the court, after hearing all the evidence, feels it's not going to work, it'll just be yet another court order observed in the breach, you have the ability to do my alternative form of relief, which is a protective separation, and here's all the bells and whistles, and here's how we do it. Would be perfectly acceptable, because we changed our trial position in closing submissions after all the evidence was in. So two very important things then that were established in 2015 by the Court of Appeal for Ontario in Wiggins. So you move forward 4 years, and you have a somewhat similar case, although there's only one child involved, in a decision where the family name is initialized. So it's AM versus CH. And AM versus CH answered about 5 issues that were bedeviling this area of law.
Sorry, before you go on, I'm sorry.
Sure.
Can we just, I just want to make sure I don't miss it. Okay, so in 2015, the Wiggins case is about temporary decision versus permanent decision, right?
It described a reversal of custody in an alienation case as inherently an interim decision.
Right. And then the other one that you mentioned about when remedy is always the discretion of the court, is that the same case? But
Yeah, it's the same case. It's the same case. That's why I said there were 2 important takeaways from Wiggins. That was the second one.
Okay.
In commercial litigation, it's discussed under the heading deciding outside the pleadings. Okay, but this is family law, and the judge is not bound by the remedies sought by either party. Okay. So, okay, so 2019 AM versus CH, Ontario Court of Appeal. 5 important takeaways from this case.
Okay, go ahead.
All right. Number 1, do you need an expert report to prove that the family dynamic is an alienation case because of the implications that the remedy may very well be this quite invasive remedy of a protective separation? You know, surely that requires expert evidence. That issue was not directly tackled in the Wiggins case. In the Wiggins case, there had been an assessment done, and the assessor, in cross-examination, I got him to admit that he never quite figured out what had bedeviled the family system, literally in those words. So that dispensed, therefore, with that we had an assessment, and the assessor couldn't quite figure it out. So the court figured it out, but we didn't have an expert report saying, yeah, looks like you're going to have to reverse custody. It's the only answer here. But it wasn't taken on directly because of that. So in AM, the other side, that's one of the things they argued on appeal. How could this trial judge have reversed custody without expert advice, perhaps even on the issue we started with earlier, Petra, weighing the short-term risk of upset to the child versus the long-term psychological implications of losing a parent? And what the Court of Appeal held, based on my submissions, because I had Dr. Stanbrook from Manitoba, never showed up on our case, but he certainly had an impact on AM. And that thinking prevailed. Since it's not a recognized pathology, that buzzword, it's just a simple way to describe a very complex process where there's maladaptive behaviors on all the family members resulting from a high conflict separation, and it's very bad for the kids. That is well within normal fact finding for a judge, is what the Ontario Court of Appeal said. No expert report required. It's a factual analysis based on the totality of all the evidence. A real breakthrough, which is consistent with the position of the courts in Alberta, Saskatchewan, and I think Manitoba as well. But there is a BC Court of Appeal case that has held the opposite, that the potential implications are so serious that generally you should have expert advice. And until the Supreme Court of Canada weighs in, or until the BC Court of Appeal rethinks that one, because most families can't afford a full-blown assessment, or if you live in a smaller town, there are no assessors who understand this dynamic. And these were all the arguments that were very persuasive to the Ontario Court of Appeal when I raised them. So that's number one. Related to that is, okay, you've made the finding of parental alienation as the primary causal factor of the family dysfunction, but do you need an expert report for this remedy of protective separation? And the Court of Appeal said, no, you don't. So another very important takeaway. Now, in making his factual and to some extent legal determination that alienation had been found, the trial judge looked at some other cases where some experts had testified and had given the court a list of non-exclusive criteria. If you're looking for alienation, you should generally see these factors in the parental behaviors and these factors in the child behaviors. Very similar to Dr. Gardner's construct that has been revalidated by Dr. Baker and the late Dr. Darnell. And so the question was, well, you're relying on factors that another judge accepted because that judge had the expert speaking to that testify. Can you do that? That expert didn't show up to be cross-examined in your case. Answer, perfectly fine. Once accepted as part of a non-exclusive calculus for determining what's really ailing the family system, other judges can rely on it. You don't have to dip in and get that expert to come and testify in your court as well. Very, very helpful, obviously, because of the cost of this sort of litigation. And that means we can learn, because you start to assemble a bunch of cases that have ultimately concluded that, yeah, there's a lot going on here and the targeted parent is not perfect, but didn't really cause this. You can learn from that. You can say, okay, so this body of case law says, here's how I prove an alienation case. And I don't need my own expert to come in and inform the court how you prove a parental alienation case. I can look at all the other cases where that was ultimately the conclusion that, once again, there's a lot going on. Targeted parent's not perfect, but targeted parent didn't cause this. Very helpful. So that's the third thing that got established by the case. Okay. The fourth, there was a complete split in the jurisprudence because of healthcare consent legislation and healthcare privacy legislation. Can you force an unwilling teenager and an unwilling parent into reconciliation therapy against their will? One line of case, I won't get into where you find the problems and where you find the answers. What your listeners just want to know is, what's the bottom line? And in AM, we once and for all shut the door on that debate. This is part of the ancillary powers that a family court has, whether under the federal legislation or the corresponding provincial provision. And courts can order families into this directive, highly psychoeducational sort of process that we call reconciliation therapy. So extremely helpful, because that's one of the most important tools we have. And the protective separation, to some extent, wouldn't work without it. So, very, very important. AM saw once again an objection to the deciding outside the pleadings. It was Wiggins #2, because with this client, given how estranged he was from the children, we were even more cautious. And we had a slow, gradual buildup to 50-50 as his ask in his pleadings. But here, both in the opening submissions, like at the start of the trial, you put in your statement of the case, if you will, or opening trial statement, we informed the court about the Wiggins case, and that, once again, it's this parent's strong preference that peace prevail, and he knows it's going to take a while to reconnect, which is why we're even proposing a build-up to 50-50, but there's meaning to the 50-50. It says to the child that both parents can make an equal contribution to your upbringing, and you should treat each equally. So there's the vision, if you will, is extremely important in resonating with the child. But it became apparent here as well, based on the testimony, this was Wiggins #2. No court order had any hope. The alienating parent in that case was simply not going to produce the child. There was no hope that you'd ever have compliance with that order. And so in closing submissions, I reminded the trial judge of my opening. It looks like, Your Honor, the evidence in this trial has proven out that there's really only two options here. Dad says goodbye to the kids forever, or we do this little detour and wind up with a healthier family in future. And both the trial judge agreed and the Court of Appeal upheld this issue. So there's AM. I think there's another key takeaway from AM. It's just escaping me right this second, but an extremely important case.
That's amazing, by the way. I just wanted to say thank you, and it's amazing because you're helping protecting the parents and the children, the family, protecting the family. So I think that's such an amazing case. I just really wanted to say that. But yeah, please go on.
Okay, so I'm just one lawyer, and between those two cases alone, I've just opened up solutions here in the alienation world. So just a month and a bit ago, I got my third Ontario Court of Appeal decision in a case called Boers versus Boers. So 2021 Ontario Court of Appeal. And this case had yet again an objection to deciding outside the pleadings. Same argument. I was able to appoint the panel. Actually, there was the lead judge on this panel had been on the Wiggins panel, but I think obviously had forgotten the case, so it helped. But so we had that same issue, and there were significant questions raised about the specifics of what the judge had set out was the to-do list if the favored parent wanted back in. Would the favored parent have to surrender their own opinion of the rejected parent? Does the favored parent have to ignore their own self-perceived journey of co-parenting and just, do this big mea culpa and say, I was wrong, it was me, etc.? And the answer is yes. That parents who are that fixated true believers in their cause to protect the children from the other parent need a complete reset, and that reset can be a condition precedent to them getting back in the children's lives. So again, extremely important takeaway. The trial judge had imposed this protective separation like immediately. As soon as we finished submissions, here's my decision, reasons to follow, because of the trauma that one of the children was really decompensating. And the trial judge had, as trial judges do, express certain thoughts, certain observations along the way during the trial, in an effort to guide the testimony, but also because Dad wasn't seeing the kids during the trial. And it might have helped had he started to see the kids during the trial. And so the argument was made that there was bias and prejudging, and it was dispensed with. So, probably less common. It's a fairly high standard to meet, but they did express it. And so that's the most recent one, which reaffirms again that it's in appropriate cases. There's nothing wrong. This is the solution of choice, and they work. That father and the two children reconnected within the first week, some month and a half to 2 months before the therapy even started. It was the structural intervention that did it, the opportunity to show caregiving to your children, which builds attachment. But that will only come out when we go back to court and the alienating parent wants back in on a faster schedule, maybe than the targeted parent thinks is appropriate. And so there'll be findings about, okay, well, what happened? How resilient are the kids? And inevitably, like in now I'm going to take you back to Wiggins. In 2016, we had a follow-on 2-week trial. Mom wanted back in, boom, right away, 50-50. Dad, after everything he had gone through for years and years and years, more cautious. And in the course of deciding what the final, for the rest of the children's childhood schedule would be, Justice Hebner, the Superior Court of Justice in Windsor, commented, and I've now used this comment in both AM and in Boers, and will continue to use it, hence the power of the jurisprudence. The fact that these protective separations do work. And Justice Hebner basically said that but for Justice Harper's intervention and placing the children with the father, the relationship was a goner. And that's even overstating it. There was nothing there. And that having done so, it was a thriving, loving, resilient relationship. And then a beautiful piece of rhetoric, Justice Harper's decision to do so was the right decision at the right time for these children. So I take that paragraph, and that now appears in every situation where I'm trying to justify reversal of custody. That, and as I said, the other ones where you now have some jurisprudence as the other parent attempts to get back in.
I'm sorry, Brian. So the 2021 case, can you just spell?
Is Boers, B-O-R-S,
yes.
versus Boers.
Okay, thank you. Yeah, that's great. That's amazing.
Okay, so you can see how the beauty of this, we take the learning that results from very lengthy, very expensive litigation, and we set precedent. And then instead of re-engaging in all of that, we say, well, the learning from Wiggins is this. The learning from AM is this. The learning from Boers is this. We don't have to relitigate those principles anymore. That's what applies in this very, very difficult area of law. And it has answered those 3 cases that I won have answered some of the most vexing problems in this area.
Yeah, and you're cutting down a huge amount of cost and time for parents, because you're now cutting out the need of expert evaluation unless it's really required to, unless it's very critical. But you can apply a lot of these into it, so you don't.
Correct.
Right, and then you cut down the time because now you don't have to litigate all this. So you're really saving parents. And when it comes to parental alienation, time is such an essence because children's growing out and the damage if you don't get solution quickly. So this is amazing.
Exactly. So there you have it. So there, in I guess precisely an hour and a half, Petra, is what jurisprudence is, why it's so important, how it helps us keep alive the insightful analysis of judges who have long since retired or, like Justice Gomery, passed on, so that the next case is going to be easier because it builds on, we've got the answers here. Now you just need to apply your facts to that conceptual base, those principles. And so hopefully it not only reduces the cost of litigation, but avoids litigation. Because, you know, I have a couple going on now where they're headed in their own way toward trials. So you say, okay, well, look, it's obvious that another form of court order changing the amount of time is not going to work. And it's obvious that more judicial admonitions and more specific parenting covenants is not going to solve it either. So what's left? The same old question of, do we give up and know the psychological consequences to the child from the loss of a parent, because that research is rock solid and beyond argument? Or do we just say, oh, I don't want to do it to these kids, and force that loss on them out of a misplaced, because A versus SNA and the UK Court of Appeal decision were both before the Ontario Court of Appeal in Boers and Bluta. They were Boers and Boers as they wrote it up. So that's the learning from all of this, which makes it a lot easier for the other families to now say, well, look, this is what you're going to face. So why can't you just share the kids? Because you're going to lose them. And in Boers, there had been an interim appearance before Justice Moss, a very senior, experienced judge, and she predicted what was going to happen from the trial and threatened the favored parent. Made no difference, but she was proven 100% right. You're going to lose the kids. We do this all the time. You're going to lose the kids. And that's what happened. So other parents will hopefully listen to their own counsel, who says, look, we see the direction that the law is developing in. They're not going to allow a dominant parent to just wipe the other parent out. And so why don't you just learn to share the kids? which is at the end of the day all anybody wants. So there you have it.
Thank you so much. I
Okay.
mean, I'm so grateful, Brian, really, really. And parents, I apologize again, we run out of time. We really held him longer than what we asked for. So thank you so much. I would love for you to come back and talk more about, I know we did an interview of you before, and for parents, if you haven't seen that interview that we did of Brian before, go into our videos tab on our Facebook page, which is VictimToHero Facebook page, and you'll find that. But we kind of touched on it a little bit back then, but I didn't feel like we had enough time. So I would love for you to come back in the future to talk about fighting false allegation.
Sure. Happy to do so.
Thank you so much. And yeah, I'm so grateful for this. Thank you. And thank you, parents. Please help like and share this video so that more people can see this. I know we didn't get to address a lot of questions, but there have been a lot that was covered today. Obviously, like the body of information out there is huge, but Brian touched on critical cases, really important cases that cover really important aspect of this, custody reversal, court decision on, whether you need to bring in expert witness, all this kind of topics. So these are really important information, and we don't really have time to go into more right now, but I'm gonna really looking forward to have Brian back. Brian, thank you so much, and thank you, parents. Please join our mailing list on our website. And I never promote this, but would love to get your help and support on our Patreon page. We have Patreon page, VictimToHero. I'm doing this. We don't have any other support. We don't have any mechanism to collect money, or in any way we're not selling anything. So any kind of support from you guys would be really appreciated. So thank you so much, everyone, and have a good day. Thank you. Bye.
Bye.
Thank you so much, Brian.